Good afternoon, folks. Let's see. Good afternoon. This is Anthony Ania of Ania, Scanlon, and Sirignano. I hope everybody's doing well and staying safe. So today our presentation on Facebook is about protecting your home and the options that are available to you when you need to make a transfer of your house. And it's a very common thing for seniors to want to protect their home and want to be able to make a conveyance of the house that is both to the people that they want it to be made to, but also is efficient and effective for purposes of capital gains taxes, estate taxes, and long-term care planning purposes. So what I'm going to do today is I'm going to go over with you some of the options that are available when you want to protect your house. And for most Westchester County and tri-state residents, and the house is usually the most valuable asset that they own, especially if you're in the middle class or upper middle class. The house could be a significant portion of your estate. So let's take a look at the different options that are available. Well, the first thing you could do is transfer your house and do a deed of your house outright to your children or loved ones or friends, whatever the case may be. But this is probably the least preferable option. And the reason why it's not a preferable option is because of the tax components to it. When you make an outright deed of your house and you don't reserve a life estate, the person that receives your house is getting the house at its fair market value when you purchased it, at your cost basis. So at your original cost basis, plus capital improvements, less depreciation. So if you have somebody that bought a house in Westchester County in the 60s and 70s, they may have paid $50,000, $60,000 for a house that's now worth $800,000. If that house is now gifted outright to a family member, a child or children, that child gets the house at its original cost basis, the purchase price, or the price, the value at the time the person received it, plus any capital improvements made to the residence, plus less depreciation. Depreciation generally happens if the person is renting the house. So if it's a two-family house, part of the house may have been depreciated, so the actual value gets reduced. The basis gets reduced. And that's not great for purposes of the individual receiving the house, because if they get it at a low cost basis, then when they go to sell the house, they're going to have to pay the capital gains tax on the sale of the house. So an outright transfer of the home without the reservation of a life estate is not a very desirable option. Additionally, from a long-term care perspective and the Medicaid perspective, the transfer of the house, unless it meets one of the requirements to be an exempt transfer, for example, a transfer to a spouse or a blind or a disabled child, or to a special needs trust for a disabled child, or if you deed your house to a caretaker child, a child that has been residing in the house for at least 2 years immediately prior to your institutionalization and provides care to you. That's considered an exempt transfer. That does not create a look-back period. Additionally, if the house is transferred to a sibling with an equity interest, that also is not considered an exempt, it's considered an exempt transfer, and it doesn't create any ineligibility for Medicaid nursing home. And now we're dealing with another component that as of October 1st, if any transfers are made on or after October 1st, that there is now a 30-month look-back period for Medicaid home care. So both from the capital gains tax perspective and the Medicaid perspective, there are negative consequences. It's creating the look-back period, which is good because you're actually transferring an asset out and you're starting the period to protect the asset. But unfortunately, the person that you've given the property to is now going to receive the property at your original basis. And when he or she or they go to sell the property, they're going to end up paying capital gains taxes. And that can be significant. The other drawback to the deed outright deed of the property without the reservation of the life estate is that the person that made the transfer is now going to lose the principal residence exclusion. So unless the person that you're transferring the home to resides in the house and owns the house for at least 2 out of 5 years, when the house is sold, then if they sell the house, they will not have a principal residence exclusion. And that is the exclusion that excludes $250,000 from capital gains if you're single, and excludes $500,000 from capital gains if you're married. So these are the negative consequences of an outright transfer, and it's not something that is often done. Outright transfers are very rare because of the negative capital gains tax consequence. Now, there is always a possibility that there could be no negative capital gains consequence. So if you bought the house for $800,000 and you now gift it to your children, well, they're going to get it at your basis of $800,000. But that's unusual. That doesn't often happen where there's an outright transfer at the time at the same price that the house was purchased for. The other thing that's lost when you do an outright transfer is the star exemption, any veterans exemption. Those are also lost because the individual that gives the house away is no longer entitled to the star or veterans or senior citizens exemption. So you have to be always very careful and cognizant of the tax consequences of making an outright transfer of your house. And there are many negative aspects to it, and we don't normally recommend it. It's a very rare occasion that we see an outright transfer of the home without the reservation of a life estate, and even with the reservation of a life estate, it only happens in very limited circumstances. That's the next type of transfer, where you deed your house away. You give away what's called the remainder interest. You give the remainder interest in your home away, and you reserve the right to live in the home. So you give the house away, but you retain the ability to remain in the house, the use and enjoyment and possession of the house, as well as the obligation to pay all the expenses for the house, the maintenance, the heating, the water, the oil and gas, whatever the case may be, and the taxes on the home. That transfer was done for many years, and it was an effective transfer for both estate tax and capital gains tax purposes, and also an effective transfer for Medicaid. From the Medicaid perspective, it was effective until they passed the Deficit Reduction Act of 2005, which basically created a 60-month look-back period for all uncompensated transfers of assets. So if you make a gift of assets, such as your house, and even though you're retaining the life estate, the right to reside in the home, it's going to create the 5-year look-back period, the 60-month look-back for Medicaid nursing home, and after October 1st, it's going to create the 30-month look-back for Medicaid home care. In the old days, the reason it was advantageous is that the dollar value of the life estate, the right to reside in the house, that was calculated and it was subtracted from the dollar value of the gift. So if you had a house that was worth $400,000 and you were a 70-year-old and you retained the life estate, that value of the life estate was subtracted from the value of the house, and that would reduce the period of the ineligibility for Medicaid. Sometimes you could reduce the period of ineligibility from 3 years to 1.5 years or a year, depending on the age of the person making the gift. That option doesn't exist anymore. That's no longer available. The problem with the reservation of a life estate in most cases is what happens if the house is sold during the lifetime of the person that retained the life estate. So I give the house to my children, and I reserve the right to live in the house. What happens if my children decide, or there is a need to sell the house while I'm alive? Well, if that were to happen, then my principal residence exclusion would only be available to the extent of the value of my life estate. So if my life estate is worth 20% of the house, then I could only use the principal residence exclusion to the extent of 20%. So if it was 250, it would be 20% of 250. If it was 500,000, it would be 20% of the 500,000. That amount would be the only amount of the principal residence exclusion that I could utilize. And the rest of it would be a transfer, and there'd be no principal residence exclusion available unless the person the house was given to was residing in the home and owning the home for at least 2 out of 5 years. And that's a rare occasion where you have a child living in the house and has been living in the house for at least 2 out of 5 years. The times that we really use a deed with the life estate now is when we have a child that's a caretaker child. That is really the only occasion that I've seen in the last 5 to 10 years where a deed with a life estate is utilized. So if I have a child who lives in the house with me, and let's say, for example, that's the only child, then I would deed the house to that child. I would reserve the life estate. That child would be considered a caretaker child if they have lived in the house for at least 2 years immediately prior to my institutionalization, going into a nursing home, and they pay, and they provide care to me, so they're a caretaker. And caretaker is kind of loosely defined. There really is no stringent standard. If you're taking care of mom and dad, providing them with food, assisting them with any activities of daily living, you would be considered a caretaker child. But the house has to be your primary residence. You have to have the documentation to support that you actually live in the house. So if you have a caretaker child and you're able to give the house to that caretaker child, then what happens is that transfer is exempt. The child gets the house and creates no period of ineligibility for Medicaid. The other advantage of a deed with the life estate is that under Section 2036A of the Internal Revenue Code, the reservation of the life estate will bring the fair market value of the house back into the estate of the person that transferred the house. So if I transfer the house to my children and I reserve a life estate and I'm still living in the house at the time of my death and the life estate has not been extinguished, then when I die, the full fair market value of the house will come back into my taxable estate, and that's okay even if there's no taxable estate, as long as it's taxable in your estate. It comes back into my estate, and under 2036A of the code, my children will get what's called a step up in basis. They will receive the house at its fair market value on my date of death. Okay? So a deed with a life estate is definitely better than an outright transfer, but it has this big problem. If the house has to be sold prior to the death of the person reserving the life estate. And I've had this come up where, for example, mom and dad deeded their house to their children, reserved the life estate, and then there was a fire. And the fire destroyed a significant portion of the house, forcing the house to be sold and the property to be sold before mom and dad died. And now they had the issue of having to, not have the principal residence exclusion on the full fair market value of the house, not being able to receive, when they received the proceeds of their life estate, that would also disqualify them for Medicaid. That's another drawback. So when you have a deed with the life estate and now you get the proceeds of the life estate if it's sold, well, now that's additional funds in your pocket, and those funds can disqualify you for Medicaid. So there are significant drawbacks in using it. What has been the best option for real property, especially the primary residence? The best option in the planning category has always been the Medicaid Asset Protection Trust. And that's the vehicle that we most commonly use when we're preparing to protect somebody's primary residence, principal residence, and even a vacation home or a rental property. We often utilize the Medicaid Asset Protection Trust. In that trust, the husband and wife or the parent transfers the house to the irrevocable Medicaid trust, and now they reserve, within the terms of the trust, the right to live in the house. They reserve the right to reside there for the rest of their lives. They also have the obligation to pay the bills. The trust will say that no one can sell or rent the house without their permission. So the house is deeded to the irrevocable trust. Mom and dad continue to live there. They're paying all their bills. The trust that we create is what's called a defective grantor trust. It is a grantor trust, but it is defective in the sense that it is not a completed gift. So when the transfer is made, technically it is not a completed gift, and therefore, for income tax purposes, the persons transferring the house to the irrevocable trust are deemed to be the owners of the house for income tax purposes. This allows them to continue to receive the principal residence exclusion, $250,000 if they're single, $500,000 if they're married. Additionally, because the trust is a defective grantor trust, and because they reserve the right to live in the house, when they die, the full fair market value of the house will come back into their estate, and they will also get a step up in the cost basis. So it's really a home run when it comes to the house to transfer it to the irrevocable Medicaid trust. It's beneficial for tax purposes, so your children will get the house at its full fair market value on your date of death. They will get what's called the step up in the cost basis. If the house is sold during your lifetime, you will get the principal residence exclusion, $250,000 if you're single, $500,000 if you're married. If it's sold during your lifetime, the proceeds of sale don't go directly back to you and disqualify you for Medicaid. There's no calculation as to what the value of the life estate is, and that you have to get that money back, which would then disqualify you for Medicaid. And also, if you say, I don't want the money when you do a deed with the life estate, Medicaid deems that as a gift as well. So as you could see, using a deed with the life estate has complexities to it. Whereas if an irrevocable trust is used, when the house is sold, the proceeds of sale come back into the trust. The creator of the trust, the person reserving the right to live in the house, still gets the personal residence exclusion. Also, during their lifetime, before the house is sold, they still get the STAR exemption, the veterans exemption, any senior citizens tax exemptions. They get all these tax exemptions because for purposes of taxes, income taxes, capital gains taxes, they are deemed the owners of the house in the trust because the trust is a defective grantor trust. The other big advantage, an additional advantage of using the irrevocable trust, is that when you pass away, there is no probate. The assets in the trust will pass by operation of law pass through the trust to your children, and there will be no probate necessary. So the terms of the trust dictate who gets the house. It goes automatically from the trust to your children, and there's no need to go probate your will when it comes to the trust. When you put the house in the trust, though, you are creating the 5-year look back for nursing home Medicaid, and if you do so after October 1st, you're going to be creating a 30-month look back for purposes of Medicaid home care. So again, the Medicaid planning aspect is always good to create the 5-year look back. The only way to protect assets is to really disqualify yourself from getting nursing home Medicaid. And you really want to do that when you're younger, in good health, and you don't have the potential in the next 5 years of needing Medicaid, whether it be Medicaid nursing home or Medicaid home care. It's most ideal to do this kind of planning, let's say when you're in your late 60s, early 70s. That doesn't mean you shouldn't do it when you're in your late 70s or 80s. It's just that the risk is a little higher that you may need Medicaid before the 5-year look back expires. And again, if that were to happen, there are still ways for us to be able to protect the house and your assets in the trust. There are things that we can still do. But from a tax perspective, the Medicaid Asset Protection Trust is definitely a much more valuable option than either a deed with without the reservation of a life estate or a deed with the reservation of a life estate. You can also use a revocable living trust and transfer your house to the revocable trust. That has all the same tax advantages of the irrevocable trust, but the disadvantage is that the revocable living trust does not create the 5-year look back. So if you take your house and you transfer it to a revocable trust, you have the right to live in the house, you pay all your bills. From a tax perspective, nothing has changed. Same with the irrevocable trust. However, with the revocable trust, you're not creating the 5-year look back. So there always exists the possibility that Medicaid could try to impose a claim or a lien on the house if you're alive and if you're no longer living in the house. So there's that window where Medicaid could try to have a claim against the house. And that's something you have to be cognizant of if you decided to put your house in a revocable trust. But from a planning perspective, you avoid probate. And a lot of our clients use a revocable trust, but they really use it prior to their wanting to do long-term care planning. Or if they're doing long-term care planning, they will use the revocable trust as a means of being able to manage their affairs and assets and the monies in the revocable trust without giving up control. So sometimes a client will say, well, I want to give up control over my house and put that in the trust and reserve the right to live there, but my monies I really want to have control over. So they'll do an irrevocable trust for the house, and they'll do a revocable living trust for the monies or the assets they want to control. So there are many different options available, as you can see. There are tax advantages to some of them. There are tax disadvantages to other options. But the key is that when you're doing this kind of planning, that you sit down with your attorney and your accountant and go over all the options and decide what is the best option to utilize. Generally, for most seniors, the best option is an option that A, gives you the tax advantages, avoids probate, and allows you to start the clock running on protecting your assets, and that is the Medicaid Asset Protection Trust, which is technically a defective grantor trust. Thank you for joining me today. I hope you gleaned some valuable information from this presentation. Again, I'm Anthony Ania, managing member of Ania, Scanlon, and Sirignano, with offices in White Plains and Somers, New York. If we can be of any assistance to you, please feel free to call us. Thank you very much.